Hello, everyone, and welcome to Thursday Talks with Chug. Each week, we cover pressing topics that matter to you and your business. My name is Arianna Gonzalez from Chug, attorneys and CPAs tuning in from our San Diego office. Please join me in welcoming partner and attorney Diya Mathews from our Edison, New Jersey office. Hi there, Diya, and welcome.
Thanks for having me, Ariana. Good to be here.
Thank you so much for taking the time. In today's session on the H1, on the L-1B visa, we'll break down the requirements, application process, and common challenges. If you're a multinational company looking to transfer employees with specialized knowledge to the US, this session is for you. Just a quick disclaimer before we get started, this conversation is for informational purposes only. It does not create an attorney-client relationship, so if you do have questions, please comment them below or email us at info@chug.com. So let's get into it. Dia, can you give us an overview of the L-1B visa? Sorry, I said H-1B. There's so many visas, sometimes I mix them up, but we're talking about the L-1B visa today.
Right. It is the alphabet soup, isn't it?
Yes,
So,
absolutely.
right. So the L-1B visa, which we will talk about today, and we'll try to finish this in half an hour. But basically, it's a work visa, which allows a business, a multinational corporation, usually, to transfer employees with certain types of knowledge. We call it specialized knowledge. So it's a visa that lets them transfer such employees from their foreign office to a US office. And it's specifically designed for employees who have deep expertise in the business's offerings of products, services, systems, something that's not commonly found in the industry. And a few things about this visa: it's been around since 1970. You can hold L-1B status for up to 5 years at a time. With the initial filing as well as extension, so capped at 5 years. You can transition to an L-1A visa status, which is for managers and executives, if you meet certain requirements. But of course, you cannot do it in the last 6 months of your L-1B tenure. And the other thing to note about L-1B visa, which makes it quite desirable to foreign nationals, is that dependents of the L-1B visa holder, the dependent spouse, L2 spouse, can also has work authorization in the US. So that's a few quick pointers about the L-1B.
Wow, that sounds like quite an attractive offer. That's not too common that your spouse can also work without separate authorization. So how do you determine eligibility for the L-1B visa?
Yeah. So it's important to determine the eligibility, and oftentimes you'll have clients, wanting to bring somebody over, right, from abroad, from their branch or affiliate abroad, but you have to meet certain specific criteria. Now, there is criteria for the employer and there is criteria for the employee, the applicant employee. So for the employer, the first requirement is that the foreign affiliate or the foreign office from which the employee is being transferred, that foreign office should have a qualifying relationship with the US office, right? And so the qualifying relationships under the regulations are parent subsidiary relationship, affiliate relationship, which means that both the US as well as the offshore overseas entity are owned by the same person or group. And the last type of qualifying relationship is a branch, which you don't really see as much these days. But those are the three qualifying relationships that you can have from a corporate standpoint for the employer. The other requirement is that both the overseas entity as well as the US entity should be actively conducting business, at least at the time that you file the application. And then coming to the employee requirements, the first requirement is that the applicant, the employee, should have worked overseas for the foreign office for at least 1 year in the last 3 years before filing the petition in a specialized knowledge role. And we'll talk more about specialized knowledge later today, but that's the primary requirement. And then you should also keep in mind that any time spent in the US in that 1 year period should be subtracted from the calculation. So the person has to meet a full 1 year requirement, 1 year period overseas, excluding any time spent in the US in visitor or any other status. And then, as I mentioned, should have specialized knowledge. So should have worked in a specialized knowledge capacity for at least 1 year. So that's the requirement for the employer and the employee.
Really good things to keep in mind. So is it possible to file an L-1B for new US offices?
Yes, and that's actually a great question. So when we say new US office, that has a specific meaning in the L1 scheme. A new office is defined as any office in the US, any US entity that has been operational for less than 1 year. So usually for new offices, we do more L1As, which are for managers, but it is very much possible to do L1B as well for new offices.
Okay, good to know. So it sounds like the word specialized knowledge is a key word here that we keep hearing. Can you explain a little bit about what that is?
I really think it's a moving target, or it's actually quite subjective. But let's try, right? So now USCIS defines specialized knowledge, and I have it here. It can be either special knowledge or it can be advanced knowledge, and they both have different meanings. So special knowledge is distinct or uncommon knowledge of the employer's products, services, techniques, or processes. And advanced knowledge is defined as deep expertise in the organization's processes and procedures beyond what is typically found in the industry. Now, these two have quite a bit of overlap. So sometimes when you get a case, you have to review it carefully and see whether you want to show it as special knowledge or as advanced knowledge. And it's quite possible that somebody might have both, right? It could be both special as well as advanced, but it's better to take a call either way, one way or the other, and then prepare the application accordingly. It's also interesting. It doesn't have to be proprietary. The knowledge that we're talking about that the applicant has, there's no regulation which says it has to be proprietary, but it definitely helps if the organization has some sort of proprietary knowledge, and it has to be noteworthy or uncommon. So that's specialized knowledge. Again, 10,000 feet overview.
Got it. Thank you for diving into that for us. Can you talk a little bit about how you screen for specialized knowledge? What does that look like?
Yeah, so when we get a case, a potential case, the first thing apart from verifying the corporate relationship between the two entities, once we clear that, then we look at the employee, right? So the first thing is, has the candidate worked for the foreign entity for at least one continuous year in the past 3 years, right? And then, so it's, the law says just 1 year of specialized knowledge, but in practice, you need more than 1 year because you want to show ideally that this specialized knowledge was first acquired and then utilized for 1 year. So it's always better if the person has been with the foreign office for a few years. But having said that, yes, we have secured approvals for people with just 1 year, as long as it's one good year overseas. Second, we look at identifying the specialized knowledge. So does the candidate have some sort of training or skill set, expertise that is specific to the employer, or that is unique in the industry? And an example for this is, oftentimes you'll have the employer say that, oh, I have this person who's very good. Maybe he's very good with Java or Python or, some sort of specific technology. But, being an expert in that technology or tool is not enough, because if it is something that's widely available in the industry, then it doesn't rise to the level of specialized knowledge. So a lot of time is spent explaining to employers what actually qualifies as specialized knowledge. If it is something for which you could hire somebody in the US, then it's probably not going to be specialized knowledge, right? The other question is, could the employee have obtained this knowledge if they hadn't worked in the organization, right? If it is not unique to the business, if it is something that is easily available in the industry, then it might not be specialized knowledge. If it is some sort of skill set which would take more than a year to train, right? If you got somebody raw and you had to train them for at least 1 year to get them up to speed, then it's starting to look more like specialized knowledge. And then we look at how they acquired the specialized knowledge. So if they say that they have some sort of skill set Maybe the organization has a proprietary tool or framework or some sort of methodology that they use. And if so, how complicated or how complex is it, right? Is it something that somebody can easily come and train in a few weeks? If so, it's not going to be specialized knowledge. But if it's going to take a person a year or so to get up to speed with this, then it's looking more like specialized knowledge. And then you also ask, how did this person get trained in this? Did they either develop this tool or technology for the employer? And you'll notice I'm giving a lot of technology examples, but it doesn't always have to be in tech, right? You could have something, for example, a kind of massage technique, right? Like, in India, we have various types of massages, Ayurvedic, things that people have been doing for years. And some of it is very specialized because you have to train for years to become knowledgeable in that. And that could be specialized knowledge because, it's not usually knowledge available in the market or in the industry. And if somebody has to spend years training under somebody to acquire this, then it could very well be specialized knowledge. We also have to explain how the specialized knowledge is critical to the employer's operations. So, even if it is actually something very unique, if it doesn't really have a big impact on the business, then it's not really going to make for a strong application. So you also have to get the employer to articulate why this particular skill set, specialized knowledge, is relevant to their operations, how it's critical to the operations. So that's, those are a few things to ask for in screening for specialized knowledge.
Wow, that does seem like quite a high bar. We did get a question from the audience. If I can interrupt you, I do want you to walk us through the L-1B application process, but do we have any information on which company pays the salary, if it's the foreign company or the US company?
That's a good question. So for the L-1B, it can be paid overseas as well. Unlike in H-1B, where you have really strict, wage requirements and it has to be paid by the US employer. With the L-1B, you have more flexibility. So the salary can be paid by the overseas entity. But again, there has to be an employment relationship with the US entity. So two different things. But you have more flexibility with the salary payment.
Great, thanks for explaining that. I hope that helps, Suzanne. If you do have additional questions, feel free to reach out to us anytime at info@chug.com and we'll connect you with Diya. So Diya, can you walk us through the L-1B visa application process?
Sure, yeah. So there's three different ways, and I'll just, give an overview. One is the blanketel. Blanketel, not everybody has a blanketel, but blanketel is a blanket authorization given to certain companies which qualify. And once you have the blanketel, you can send your folks, your employees, to the consulate directly for a visa interview. You don't have to file a separate petition for each employee, right? But there is, again, specific criteria which has to be met to get the blanketel. The vast majority of companies which don't have blanketels, then they would file a petition with USCIS, and that has to be filed for each employee. So in the initial filing, unless it's a new office L-1B, in the initial filing, you can ask for a 3-year term, and then you can ask for increments of 2 years, up to a maximum of 5 years, as we discussed earlier. The third type, and it's a very small category of people which qualify for this, Canadian nationals can apply at the border, at the port of entry into the US. But again, that's only for Canadian nationals. So for today's presentation, maybe we can talk a little bit about the application that we file with USCIS, because that's what we call the individual petition, and that requires a good amount of work. Okay with that, Arianna?
Absolutely, yeah, that's perfect.
So with the L-1B petition, which we filed with USCIS, and again, it's a custom application for each employee. So that's basically the form I-129 with the L supplement. And then when we prepare a case, a lot of effort goes into the support letter. So support letter is the cover letter, and that's usually from the petitioner explaining the applicant's specialized knowledge. Of course, you meet all the other requirements such as the corporate relationship, but explaining and evidencing the specialized knowledge is is what takes up a lot of the bulk of the work in preparing an L-1B petition. So, and I can talk a little bit about, how we go about it. So we start with the description of the employee's specialized knowledge. Usually we work with the employee and their manager because, that they are probably the most well positioned to explain what exactly the person does and, why it's important to the company, the business. Second, we talk about how the specialized knowledge was gained, special projects or assignments that the employee worked at in the foreign office. And if applicable, you can also talk about why they were selected for these projects. It could have been because they had a prior foundation in, certain, skill set or their knowledge, and then, they were building on that knowledge with these projects. We talk about whether the employer has any kind of proprietary information. We call it IP, intellectual property. So intellectual property protections, if the employer has invested in them, like patents or copyrights, trademarks, etc., for this proprietary knowledge, then that gives a lot of credence because it shows that the employer actually considers this important and unique enough to get the IP protection. The job duties for the employee should be drafted very carefully. So we have to explain in detail what the person's job duties were at the foreign office. And we also have to explain, the counterpart, what the person is going to be doing in the US. So in the job duties section, both at the overseas entity as well as in the proposed role in the US, we should reference a specialized knowledge so that, for example, if it's let's say it's somebody who's a software engineer and maybe there is specialized knowledge, but if the job duties look like vanilla software engineer tasks, then the USCIS officer is not going to be impressed, right? Or it's not going to be convinced that there is specialized knowledge. So as you draft the job duties section, you have to weave in references to the specialized knowledge because you want to show that this person's duties or tasks of the overseas entity are different from those of the, from those of others in the organization. If there is going to be a third-party placement, so if the L-1B beneficiary is going to be working at a client location, then there is additional scrutiny. So you have to talk a little bit more about the control and supervision by the petitioner. And we have to explain why it is not a labor for hire arrangement. So with H-1Bs, we have this concept of, that it should not be a staffing arrangement and that the employer should be controlling, etc. With L-1Bs, the term is labor for hire. So the L-1B beneficiary, if placed at a third-party location, should not be a labor for hire situation. So what they mean is that the L-1B beneficiary should not be just filling a position at the client site. It should actually be more geared towards, running a project or driving a project for the petitioner. We also try to give a comparison of their skill set or their rating against other team members to distinguish them from others in the team. Now, so that's just a few things to keep in mind when preparing the support letter. So you can say all of this, but you also need to provide evidence, right? So that's sometimes the challenge with the L-1Bs, that that they have some sort of unique or some sort of uncommon knowledge or skill set, but they don't really have the documentation or the evidence to show it because sometimes you're not really building that record, right? You're just doing your work and you might have a lot of things in your head, but you might not have that evidence to back it up. And USCIS takes a position that don't tell us, just show us, right? Show us the specialized knowledge. So the evidence that you can include would be employment verification letters, and I tried to get them from the managers or the people who have oversight of what the person does, as opposed to getting them from HR, for example, right? Then if the employee, the L-1B beneficiary, if they have intellectual property, if they have patents or trademarks or copyrights in their name, or if they are named in the employer's IP protections, then that's, that also serves as good evidence. If there are training certificates or trainings that the L-1B applicant has done within the company, that also carries a lot of weight. If you're giving training certificates, then you should also try give a curriculum as to what was covered in the training. Performance appraisals are good if they show a high, or a positive rating for the applicant. Technical manuals, user guides, or white papers, or any other work product prepared by the L-1B beneficiary, and especially if they have their names and if they show that they prepared it or they updated it, then that also is helpful to use. You can also include confidentiality agreements executed between the employee and the company, especially if there are little more detailed confidentiality agreements, because the employee was handling something super critical or super confidential. You could include those confidentiality agreements as well. And then the numbers are very helpful, because you can say all of this, but the USCIS officers like to see some numbers. So if you can quantify in terms of, okay, this is the dollar amount impact that this specialized knowledge has, right? In terms of the organization's revenues in the US, or if you can talk about the amount invested by the company in training this employee. So those type of numbers are also good. And then the last thing would be expert opinions. I personally don't like to use expert opinions for L-1Bs, but a lot of practitioners do. So, that's also something to consider when building the L-1B application or petition. All right, so
Things to
that was a
keep in
lot.
mind.
Back to you, Arianna.
Thank you for diving into that for us. Do you also have to explain how the specialized knowledge will be used in the US role?
Yeah. And so, with L-1B applications, petitions, there are usually two parts to it. In the first half, we talk about the employee's specialized knowledge and what they have done at the overseas entity, right? And that covers everything that I went over before. But the second part of the application is also explaining what the person is going to be doing in the US coming here, because the whole purpose of this transfer is that you want this employee to come and use their specialized knowledge in the US, and you're claiming that you want this particular person to come because you're not able to find a suitable person in the US. So you have to have a good detailed section explaining the proposed role in the US, where you talk about the detailed job duties for the proposed role. Again, you can talk about the revenue impact that this person is going to have in the US in the specialized knowledge role. And if there's third-party placement, etc., you can also get letters from the third-party client confirming that this is what the person is going to be doing. One thing to note here is third-party placement. I referred to this earlier. When there is a third-party placement with L-1Bs, there's going to be additional burden of proof on the petitioner, on the employer, to show that it is not a labor for hire situation, that you're not just, it's not a staffing arrangement. So you have to show that the employer controls the person, that the employer is driving the project or the work, and that it's going to be the employer supervising the person.
Oh, that seems like quite a lot of work. So after submitting all of these documents to USCIS, can one still get an RFE? And what are the common L-1B RFE issues?
Yeah, there used to be a time when the L-1B RFE rate was really high. So I think that keeps fluctuating. Now with the new administration, we're probably all expecting more RFEs anyway. But a lot of these RFEs that we get them, there's a certain template to it, right? There's a certain language. And you can see that they're following the policy memo. So USCIS came out with a policy memo and some of it is based on case law and things like that. But from the policy manual, there's very clear description of what they want to see in an L-1B petition. And so when you review these RFE, requests for evidence notices, you'll see sometimes, that they are oftentimes that they are actually just copied from the policy manual. So the first thing, usually, they'll uh, couch it as, okay, the person does not seem to have specialized knowledge, like you've not explained the specialized knowledge in detail. As having the applicant not really possessing the specialized knowledge. Second, that the applicant does not seem like they'll be using the specialized knowledge in the US, right? They could also ask why local US office workers cannot do the job. And then if they see that there is a number of other employees from the same employer, from the same company at this particular work site, third party work site, they could then question whether it is really specialized knowledge. If you have a lot of people doing similar work, then what kind of specialized knowledge does this person really have? So those are the typical RFE, triggers or issues. And, it's pretty wide because when you say that somebody doesn't have specialized knowledge, you're challenging it, then employer has to pretty much provide all of this information again and try to bolster it.
Wow, so I do want to ask you a little bit about how we can avoid RFEs, but we do have another audience question if we can get to that really quick. Are you able to change employers on the L1 visa? Is that something that's allowed?
So you can do an L1B amendment. If the question is, if you come on an L1B and can you switch to some other employer, then the answer is no. But if it is another employer in the same organization family, right? So let's say if an organization has two subsidiaries in the US, both owned by the same parent overseas, and you wanted to transfer them from subsidiary A to subsidiary B, then that can be done, and that would be an L1B amendment because you're transferring within the same organization. But otherwise, in general, you cannot transfer that L1B to an unrelated employer.
Thank you for clarifying that. If you do want to reach out to us, Sunny, we'd be happy to help you out as well. So, Diya, can you explain a little bit about what we can do to avoid RFEs for the L-1B petition? Is this something that we can do and take action against this, or what does that look like?
Yeah. So if there's one thing we know by now, it is that you can't really avoid an RFE. I mean, there's no way to guarantee that there won't be an RFE because you could prepare two identical petitions, and one could go through without any issues. The other one could run into an RFE. So that's just the nature of how it works. But what can we do to minimize the chances of an RFE? I guess what we know by now is try to provide clear and quantifiable proof of the specialized knowledge. Explain the specialized knowledge in a way that the USCIS officer will understand, right? So USCIS officers are not technical experts. They might not have engineering or scientific backgrounds. And so you want to try break it down and explain it to them in a way that they understand. Segregate the evidence. So in terms of the, explaining the specialized knowledge of the job duties, it helps if you can tab the corresponding evidence, with the specific job duty. So that's a little more work instead of just lumping all of the evidence in one exhibit. If you can tab it so that you can draw the connection with corresponding job duties, and it's helpful. And then use a lot of visual aids like organizational charts. Now, org charts are more important in the L1A context, as we know, but even with L1B, sometimes the org chart helps if you can show that the L1B beneficiary is not, at an entry level position in the org chart, right? If they're fairly high up and there's other people under them, so that also makes the case a little stronger. And then, as we discussed earlier, give all the training materials, IP patents, And if it's, if it's somebody, if it's an employer who's new to the L-1B program, then you have to spend some time educating the employer on what type of evidence would be useful. So investing that time talking to the employer also helps. And you want to distinguish this particular employee, this L-1B employee, from others in the team or others in the organization, and kind of show that he or she is a superstar. So those are, a few things you can do to make a good petition. Not saying it would necessarily avoid an RFE, but you can always respond to the RFE as well.
Absolutely. Yeah, we want to do our best, if we can to avoid that, but if we can't, then we'll handle it when it comes. So, thank you so much, Dia, for taking the time to answer all of our questions and sharing your insight with us. We really appreciate it. Thank you, everybody, for tuning in and participating and asking questions. Make sure to join us back here next Thursday for more pressing topics that truly matter to you and your business. If you have any questions or suggestions, send us an email at info@chook.com. Make sure to like this video, subscribe, share it with your friends, and reach out to us if we can help you out. See you guys next week. Thank you, Dia. Thanks, everyone.
Thank you, Arianna.